Honorable Court of Appeals of Tennessee is now in session.
Good morning, counsel. Before Mr. Hibner calls, I always forget to wait for that to be done. Good morning, counsel. Before Mr. Hibner calls the case, just mention to you that we don't anticipate any technology-related problems, but if we should have everybody just take a deep breath and we'll pause and work through it, but everything's working very smoothly. Mr. Hibner, call the case, please.
Moore Freight Services, Inc. versus Grant Mize et al.
We'll hear from the appellant.
Thank you. May it please the court, my name is Samantha Lunn. I'm a member of the Chattanooga Bar, a partner at Hush Blackwell, and I represent the appellant plaintiff, Moore Freight Services. I will refer to my client as Moore Freight or plaintiff throughout my argument. I have asked to reserve 3 minutes for rebuttal.
Yes, that'll be fine, counsel.
Today, Moore Freight is asking for the court to reverse the trial order because it is not consistent with Tennessee precedents on attorney-client privilege, the work product protection, or the doctrine of implied waiver and at-issue waiver. The trial court ruled against my client, Moore Freight, based on the doctrine of at-issue waiver. It is Moore Freight's position today that the wrong standard was applied with respect to work product, and the application of the Bryan test to attorney-client privilege was not applied correctly. The certified question before the court today is whether Moore Freight waived the work product, attorney-client, and common interest privileges and protections by placing the internal investigation at issue in this litigation. The standard of review for this matter is de novo because the waiver of privilege is a mixed question of fact and law, while the application of the privilege would be reviewed under an abuse of discretion standard. The gravamen of the defendant's position, which the trial court adopted, is that the references in the pleadings to an internal investigation put the investigation fully at issue in this case and open the door for the defendants to have discovery of the entire substance of that investigation. This is primarily based on paragraph 48 of the complaint, which I will read into the record in full for the court. Paragraph 48, after reviewing all of the information available, it was determined that the severity of the conduct, the potential damages that have been or was caused to Moore Inc.'s customer relationships, which are built on trust, and other substantial harm that could have been caused to Moore Inc. and Dasky made it impossible for Mize and the other employees involved in the scheme to remain employed by Moore Inc. I took the time to read that full paragraph into the record because noticeably the word investigation does not appear in paragraph 48. Which is where the court spent the majority of its time in reviewing the motion to compel. It is correct that the investigation appears 3 times in the 16-page complaint, paragraph 41, paragraph 42, and paragraph 47. However, these references are part of the timeline establishing when Mr. Mize was terminated by Moore Freight. There is no substantive material or information related to the internal investigation disclosed in any pleadings by the plaintiff. This is demonstrated by the fact that neither Hush Blackwell as the trial counsel for Moore Freight nor counsel for the defendants have any information about the substantive communications and work product developed by Vincent and Elkins, the law firm that conducted the internal investigation.
Ms. Lunn, is it your position that Moore Freight would have fired Mr. Mize even without the investigation?
Yes, Your Honor.
Based on what?
Your Honor, Mr. Mize came to Mr. Hoppy and he disclosed the conduct that resulted in his termination, which was payments being made to a principal contact at a customer in violation of company policies.
So if they could have terminated him based on him just making that statement, why did they even do an investigation?
It was necessary to do the investigation to determine the scope of the damage that incurred and to determine if there were other employees that were involved in the scheme.
Did they fire him immediately upon making the statement, or did they fire him at the termination of the investigation?
They fired him after the investigation.
Thank you.
In issuing its trial court opinion, the Bryan decision was primarily what was relied upon by the trial court. This is a 1992 case by the Criminal Court of Appeals that was adopted by this court in Culbertson in 2012. This provides a test for the at-issue waiver as to the attorney-client privilege. First, the assertion of the privilege was the result of some affirmative act, such as filing suit by the asserting party. Second, through this affirmative act, the asserting party put the protected information at issue by making it relevant to the case. And application of the privilege would have denied the opposing party access to information vital to its defense. None of those circumstances are present here. Defendants would like this court to see that the affirmative act standard has been met by the simple filing of a lawsuit, but that is not enough. The filing of the lawsuit itself has to put the substance of the attorney-client privilege information at issue. Otherwise, every other case would be subject to the Bryan test. The cases put forward by defendants for these circumstances involve cases that involve the conduct of an attorney, malpractice, or retaliation claims where the investigation is part of the defense. Here,
for interrupting, counsel, as I
That's fine.
understand, the appellee filed a counterclaim in this case. Is that correct?
that's correct.
And is raising also a defense that the termination was a pretext. And so would that place the internal investigation at issue in this case, since it is referenced at least 3 times in the complaint?
No, Your Honor, it would not. And the reason it would not is because the pretext argument is a specific doctrine related to retaliation and harassment claims, which opens up investigations under the Farrar-Ellerth standard. And so in this case, that's not what we have here. We're not using the investigation to conduct to justify the decision to terminate. The question before the court with respect to the breach of contract question, both their defense of first breach and their counterclaim for breach of contract is, did Mr. Mize's conduct occur before or after More Freight chose to not pay under the employment agreement? Under those circumstances, the fact of the investigation is not relevant, and whether or not it's a pretext is not relevant to the first breach analysis.
Thank you.
I want to address quick before I move on to Boyd, which again, we believe is the case that controls work product. I want to address the third element of Bryan, which is that it must be vital to the defense. This builds on the question I just answered from Judge Frierson. As I mentioned, it's the conduct of the 2 parties that breached the contract that's relevant to answering that question. The investigation is not alleged to either reform any breach, nor is it considered a breach itself. As we've argued in our brief, we believe that it is this court's 2002 Boyd versus Comdata Network decision that makes the determination regarding implied waiver of the work product doctrine. This court's precedent has treated attorney-client privilege and attorney work product separately, and we urge the court to continue to do so, as they are separate and distinct doctrines. Boyd is the only published Tennessee case on implied waiver of work product in the context of litigation. In Boyd, rather than being an elemental test, it provides 3 categories in which are the only instances in which work product is waived. Number 1, the litigation puts the attorney's work product at issue by asserting claims or defenses based on advice of counsel. 2, where a party calls its attorney as an expert witness. And 3, where the attorney's conduct is central to the case. None of these circumstances are present here. And the way for this court to reconcile the Bryan decision adopted by Culbertson and Boyd is to indicate that 1 is an elemental test for the attorney-client privilege. That is the Bryan case. The other is a categorical test for work product, and that is Boyd. Before I make my final remarks, I'd like to quickly address.
Counsel, I'm
Yes.
sorry, before you get there, the
That's fine.
determination letters state the company has conducted a thorough investigation, which included open admissions by you and others of misconduct that occurred. The company acknowledges your assistance with the company's investigation. Nevertheless, the company has concluded that you engaged in conduct materially injurious to the company. I mean, that seems to read that the termination letter is certainly referencing the thorough investigation. Was there any investigation done by someone, by the company other than through a law firm?
The only investigation done at the company was by Vincent and Elkins. There was a parallel investigation done by the customer.
All right, well, the termination letter talks about after the thorough investigation, this determination has been made. Does that put the investigation at issue?
No, Your Honor, I don't believe so. Because again, with regard to a claim as to the breach of contract and the first breach doctrine, it is the timing of the two conducts that are a breach, namely first, the violation of the employment agreement by the conduct of Mr. Mize in making the illegal payments, and then the conduct of More Freight in choosing not to make payments under the employment agreement.
Okay, go ahead. Your time runs out.
In the brief, the appellees have argued that the work product argument before this court is premature. As I've recited the question to the court is aware that work product is in the question set forth before the court. The appellees did not oppose the motion to certify. They negotiated the question to be certified, which includes work product. And then the language of the trial court's order includes work product. So we believe that the question of work product is before this court and is not premature.
As I understand, the trial court accepted out opinion work product. Is that correct?
No, Your Honor, it's not. The trial court has said that all documents have, all privileges and protections against all documents related to internal investigation have been waived. He looked at certain documents in camera review and has ordered those specific documents produced. But then he will allow future documents to be produced based on the order already put down.
Thank you.
And Your Honor, as a final comment, I just want to say the non-substantive references included in our litigation, in our pleadings, if those are found to be sufficient to waive all privileges and protections, it will have a chilling effect on attorney work and on the attorney-client communications. Thank you.
Thank you, counsel. You have your time for rebuttal. We'll hear from the appellee.
May it please the court, James Stovall for appellee Grant Mize, and arguing today on behalf of both appellees. I would like to start with Judge Frierson's question about the scope of the trial court's order, because Moore's position is simply incorrect. The trial court's order does not address the Vincent and Elkins opinion work product, and I'll point to two places in the record that make this clear. One is the agreed order, and I think it's important because it was an agreed order by Chancellor Weaver that certified this for appeal, and this is at page 1292 of the record. In that order, Chancellor Weaver specifically noted that the order that is at issue on this appeal does not address the Vincent and Elkins opinion work product. That is not addressed by the order that is the subject of our argument today. And in Chancellor Weaver's bench opinion, I would also note pages 1102 and 1101 and 1102 of the record. Defense counsel actually noted on the record, and it's part of the bench opinion, that although, of course, I mean, we do intend, Moore's right, we want all of it. They're not wrong about that, but we have to make another showing. Chancellor Weaver was clear, we're not going to get it just because Chancellor Weaver found that it's been waived for the materials that were reviewed in camera. And as counsel for defendants below put it, we have to show a link. We have to show a connection between the materials that Chancellor Weaver reviewed in camera and found have been waived and the Vincent and Elkins opinion work product. So,
Mr. Stovall, so basically the chancellor is, as to the Vincent and Elkins opinion products, what he's saying is, if you guys want to see that, I need to review it first and make sure that it's connected, but he's not going to go back through the argument about at issue again. Has that issue been decided?
He's going to see if that material falls within the scope of the earlier ruling. So, and here's the part of it, Judge Davis. Chancellor Weaver's order is limited to materials that Moore Freight actually reviewed and relied on in deciding to terminate Mr. Mize for cause. So if we can't show, after we, assuming that the order is affirmed and we're able to review the material, if we can't show that the opinion work product has any connection to what Moore Freight actually relied on, then it would fall outside the scope of Chancellor Weaver's order. And I think, Judge Davis, you're also right that, Chancellor Weaver showed how careful he was here. It would only happen after another in-camera review. So the order today is much narrower than Moore's arguments suggest. And the bulk of the brief is focused on opinion work product. And what they're focused on is the Vincent and Elkins opinion work product. That Chancellor Weaver hasn't even ordered to be disclosed yet. So that's the extent to which their argument is premature. Now, it may be that the materials Chancellor Weaver already reviewed in camera include some work product. It looks like there may be some fact work product in those materials. We haven't seen them yet, but the work product that Moore has been most concerned about, the Vincent and Elkins opinion work product, has not been reviewed in camera and has not been ordered to be disclosed yet. I'd like to address now the issue that Judge Davis and Chief Judge Sweeney both asked about, and that is, how is the material in the investigation relevant? Why is the investigation at issue? And the problem is, for Moore Freight, as Chief Judge Sweeney noted, from the very beginning, it has justified its for-cause termination based on the investigation. That's not just a litigation position. This isn't a case where that's something after the fact argued by either of the parties here. In the termination letter itself, it pointed to the investigation to justify its termination for cause. And it used it in the same way in its verified complaint. The idea that the complaint does nothing more than reference the investigation is not a fair characterization of the record in Chancellor Weaver. That argument was made below, and Chancellor Weaver correctly rejected it, because if you read paragraphs 41 through 48, it's about the investigation. Even if the word only appears a few times, the information that the verified complaint alleges Moore Freight relied on is information, and this is in paragraph 47, quote, disclosed in the investigation. In fact, the complaint says that it's the details disclosed in the investigation. And paragraph 48 actually walks through findings, and I think this is important. Paragraph 48 walks through findings that the complaint alleges Moore Freight was able to make based on the information disclosed in the investigation, that the conduct was severe, that it injured customer relationships, and that it caused other substantial harm to Moore or Dasty, the parent. The reason those findings are asserted, that's the definition of cause in the employment contract. Moore Freight, the reason that this is relevant, if Moore Freight breached the contract, it can't enforce the contract. This is a non-compete case. If Moore Freight owes Mr. Mize $600,000, it can't enforce the non-compete. And the first breach argument has to do not just with whether the conduct occurred before Mr. Mize's termination. The first breach argument has to do with whether that conduct gave Moore cause under the contract. And it was the investigation that Moore says gave it cause. That's why it may have. So Judge Davis, would it have fired Mr. Mize based only on his informal statements to Mr. Hoppe, who, by the way, had an interest to get rid of Mr. Mize, and that gets into our pretext argument, who by the way, became the president of Moore and Wiley. But the record doesn't answer that question, Your Honor. They've never argued below that they would have fired him anyway. The record before this court is that they fired him only after the investigation, based on all the information reviewed. And one reason that's the case, and Chief Judge Sweeney, this goes to the termination letter too. One reason, Your Honor, I can't hear you.
Yeah, your volume's not working.
Oh, mine or can you hear
No,
me?
Judge Sweeney's.
Oh.
Ms. Sweeney, we're having trouble with your volume, with your microphone.
Who is?
Oh, now
There we go.
There you are. Now you're good.
Okay, are we back?
Yeah.
Very good.
All right, counsel, let's try again.
Okay. You were asking a question, Chief Judge.
No, I was just telling you I couldn't hear you.
Oh, okay, okay. So here's what I was saying, that on the record before this court, Moore has never said it would have fired Mr. Mize based on his informal statements. The record before this court is that it was at the end of the investigation, based on all the information disclosed, that Moore decided to terminate him for cause. And that's the issue. Even if they might have decided to terminate him without cause, based on the informal statements, the cause definition in the employment contract has an element of harm to customer relationships. And there's been no evidence or even argument by Moore that what Mr. Mize told Mr. Hoppe informally gave the company any basis to find harm to customer relationships. So even if they would have terminated him, there's nothing in the record that suggests they could have terminated him for cause without the investigation. So the verified complaint, the response to or answer to the counterclaim, and there's a third affirmative act that Moore Freight engaged in here to inject the investigation into the case. Moore Freight filed an affidavit from Mr. Hoppe himself that attached the termination letter, and also attached a quote unquote witness statement that Vincent and Elkins had Mr. Mize sign in the investigation. So this isn't the only part of our argument, but it's an important part. Not only is Moore pointing to it in its pleadings, Moore has made clear it intends to rely on that witness statement to justify, to defend its termination. Well, that witness statement is part of the investigation. That witness statement was obtained by Vincent and Elkins. That witness statement is work product of Vincent and Elkins. So what Moore Freight is doing here is using one document from the investigation, but withholding the rest. So even apart from the at issue, even apart from its pleadings and arguments, it's using a document obtained in the investigation. So Chancellor Weaver correctly found, as to the limited set of materials he reviewed, that those materials had been put at issue and that privilege and work product had been waived because Moore injected it. It was Moore's affirmative acts that led to the privilege objections being asserted. So, and Judge Frierson, that's the case even with Moore's answer to the counterclaim. In response to the counterclaim, Moore Freight did not simply say, we had grounds to terminate Mr. Mize. Moore Freight said it was the investigation that resulted in his termination, not the planned corporate consolidation. That's part of our counterclaim, that really what was going on here is they wanted to eliminate Mr. Mize's position, and this gave them a chance to do it without having to pay him $600,000. In response to that claim, Moore Freight did not have to mention the investigation. It could have said, no, we had grounds to terminate him for cause. It didn't do that. It again, affirmatively, voluntarily said it wasn't the consolidation, it was the investigation that resulted in his termination. So all three elements of the Bryan test were satisfied here. Affirmative acts, it's relevant to whether the contract is enforceable. And how is it vital? How is it vital to Mr. Mize's defense? Mr. Mize cannot fairly address whether the internal investigation gave Moore Freight grounds to terminate him for cause without being able to see the information from the investigation. So those three elements were satisfied here. What about this distinction that Moore's arguing between attorney-client privilege and work product? I want to address that briefly. Moore is confusing waiver and the substantial need test for getting work product under Rule 2602. Waiver and substantial need are separate grounds for discoverability. You can, even when work product has not been waived, if you can satisfy the 2602 test of substantial need, you can get work product. But Boyd itself makes clear that those are distinct grounds for discovery. And here's how it does this, or one way it does this. In Boyd, this court talked about burden shifting. And it's only after the party asserting work product establishes that it has not been waived, then the burden shifts to the party seeking discovery to show substantial need under 26023. So Boyd is not saying that substantial need is part of the waiver test, that there's no need for two tests. There's no need for two tests. And there's certainly no need to conflate waiver with the 2602 substantial need test. And Boyd itself makes this clear, and this court made this clear, and it's only after ComData showed it had not waived work product that Boyd, the court then went on to address whether Boyd had established that it had substantial need. And another reason not to look to Boyd on this, Boyd is not an at-issue waiver test. The trial court's limited order should be affirmed.
All right, thank you, counsel. We'll hear from the appellant rebuttal.
I want to go directly to the issue as to the breach of contract claim. And I'm surprised to hear counsel for the defendants arguing that the investigation is determinative of the breach of contract claim. I would love to be able to win this case by going in and saying, we did an investigation, therefore we rightfully terminated Mr. Mize. That would not fly. It's his conduct that matters. I can't justify a breach by my client because my client did an investigation. And that's what we're talking about when we're talking about at issue here. Counsel for the defendants has now used the word investigation during this hearing more times than it has been used in the pleadings. It is not the investigation that justifies the termination of Mr. Mize, and we will never prevail at court for that. It's his conduct and the harm that was being caused to More Freight because of his conduct, and continues to be caused as he violates the restrictive covenants that remain in place through November.
And how did you learn about the harm that came about from his conduct?
Well, as I mentioned, Mr. Mize came and told Scott Hoppy about what he was doing. He was making payments. We have characterized them as bribery, but he has made payments to our customers' main contacts in order to get business to flow. That in and of itself.
And how did you learn about the resulting harm from that conduct?
We learned about the harm through the investigation, but with regards to our termination, it's not what we knew at the time that we terminated, it's what he was doing. And he was aware of this. I also take issue with the fact that the idea that we're using the witness statement as both a sword and now a shield. I'm sure all of us have produced witness interviews and witness statements in cases, which has not opened up our entire files to be looked at as to why we interviewed people or what they said. Surely limited questions can be asked regarding whether or not an upjohn warning was given to Mr. Mize, but this does not justify the entire opening of the attorney into the attorney files, which is what they would like to have happen here. The witnesses, the information, everything that was available in the investigation is available through the subpoena power. What they'd like to do is piggyback on the work of the More Freight attorneys rather than do it themselves. The Boyd court knew of the Bryan standard before it issued its opinion. We believe that the only way to reconcile Boyd and Bryan and to bring much needed clarity to this issue is to adopt them as two separate tests, put those together in an order that reverses and remands the trial court order in this case.
Thank you, counsel. Of course, thanks to all counsel for both sides, and we appreciate the oral argument today and your briefs in this matter. Mr. Hibner, if you'll please recess court till our next regularly scheduled case.
This honorable court is now in recess until 2:30 p.m.
Thank you, counsel.